Hello, everybody. Hello, hello. And unscheduled, non-scheduled. Little lunch and learn today. I came across this deposition and I thought, oh, I have to share it. Just making sure I'm lined up here. I do have comments turned off. I would like to read through a little bit of this deposition, everyone, and then I will do a Q&A after and turn on the comments. But I do like to make it through the document a little bit before we do comments, and this is actually quite interesting. We do have a lot of trolls out there, so it just is easier for me to have the comments off. So welcome in, welcome in. Now, what I have here is the first that I've seen of any kind of discovery regarding what's been going on in the executive branch. We've got, I don't know, around 170 lawsuits, give or take, that have been filed against the administration for various things. And one of the big things has been terminating employees. This is a lawsuit that was brought by the American Federation of Government Employees, AFL-CIO, and American Federation of State, County, and Municipal Employees, which is also known as AFSCME here. AFL-CIO, of course, they are the plaintiffs, and they brought this lawsuit against the Office of Personnel Management. Now, this particular case you can look up online. This is the case number here, and it has been ongoing. This is where they have terminated a whole bunch of people and claiming that they had bad reviews, that they were not good employees. And so these two unions have brought a lawsuit. This particular case, we've been waiting to get some discovery, or on any of the cases, and discovery is the investigation time in any lawsuit. And this was just released yesterday, this deposition. Now, this deposition, the witness is under oath, and it is quite long. I'm not going to read all of it today, but just to give you a little flavor of how crazy this whole thing is. I thought this was very informative. So for anyone coming in, this is going to be the plaintiffs asking the questions. We'll have a direct examination, but it actually gets flipped to a cross-examination type situation. And there is a lot of hostility involved. And the person being questioned is Noah Peters, and he works for the Offices of Personnel Management. So he works for the administration here. The deposition itself was done on March 26th, but again, it wasn't made public until yesterday through a filing in court. So I'll go ahead and get started. I'll go about we'll do about 20 pages in until they start Exhibit 1, and then I'll do a Q&A, and I will come back again and read more once I go through the exhibits, but we'll just kind of do our introductory piece today. So welcome in, and this is very interesting. I think, well, it's interesting for me. And as usual for all of my deposition readings, everything is color-coded. I will put my sticky note back up. Hopefully I'll remember each time. But we have March 26th here, and the location was DC. These are the appearances for the plaintiffs. So our two unions here, the American Federation of Government Employees and American Federation of State and County and Municipal Employees. So we have all of our attorneys here set out. And then we have our attorneys for the, this is actually just the second page here of the attorneys for the unions. All right. And now on behalf of the defendant, we have the Department of Justice, right? So we have the DOJ here, and he will be the one objecting. And then we have the counsel for the Office of Personnel Management here. We have some co-counsel, videographer also present. And then we have a list of exhibits. And I will come back and do another live going through this deposition. and actually going through these exhibits because they're very important. Again, this is the lawsuit where they fired a whole bunch of people saying that they had a bad performance, and the employees who were terminated said, we don't actually have that. So these exhibits are what the plaintiffs are going to use to go forward on their case and ask the witness about. I won't be going through the exhibits again today. I'll just kind of give us our intro here. And it is very combative, so keep that in mind. We also have declarations of Charles Ezel, who, again, is kind of in charge over there, and then Noah Peters, who is the person being asked the questions today. So here are our proceedings introduction with the videographer. And we do have a swearing in moment. We've got introductions here. So I would let you know anything in green is going to be the plaintiffs, right? I mean, you have to have AFSCME green, of course. And then the defendants, so the Department of Personnel Management and the Department of Justice are in orange. And then anyone else is in yellow. So the witness is actually going to be in yellow, in case you're just wondering. And that just keeps everything nice and orderly here. So I do have a sticky note, and I will add that here. And I'll read about 20 pages. It is, again, quite interesting, and then I will open the floor for questions and answers. Boy, I really hope I'm in frame here, everybody. That's the one thing about having comments off, is it's a bit difficult to make sure my frame's okay. All right, here we go. All right, counsel and all present, including remotely, will now state the appearances and affiliations for the record, beginning with the noticing attorney. So Miss Leonard, she's the one asking the questions. Good afternoon, Daniel Leonard. With me as counsel for plaintiffs, Robin Tholen, Matt Blumen, Rushab Sangvi, and Pooja Chuduri. And I apologize, I'm sure I'm not saying the names correctly. And then next we have Mr. Fuch, Yuri Fuch from the Department of Justice on behalf of the defendants. With me is Chris Hall and Bob Bigler. Videographer saying, will the court reporter please swear in the witness, and then counsel may proceed. The court reporter is saying, okay. Please raise your right hand, whereupon Noah Peters, called as a witness and having been first duly sworn to tell the truth, the whole truth, and nothing but the truth, was examined and testified as follows. You may proceed, and then we will start with our examination. Again, the union attorneys are questioning the employee from the offices of personnel management. All right. Okay, ready to proceed, Mr. Peters? Yeah. Good afternoon, Mr. Peters. Again, Daniel Leonard, counsel for the plaintiffs. Mr. Peters, did you review any documents that refresh your recollection in preparation for this deposition here today? No. Did you review any documents on your own without counsel in preparation for this deposition today? No. You are currently employed as the senior advisor to the director of the United States Offices of Personnel Management, correct? Yes. And you began your federal employment in that position on January 20th of 2025, is that right? Yes. You started working at the OPM on Inauguration Day? Yes. Did you watch the inauguration, or did you get right to work? Objection, vague. We watched the inauguration. And how long did you spend watching the inauguration that day? Maybe an hour. And Inauguration Day on January 20th, that was also a federal holiday. Martin Luther King Day, right? Yes. And so that was a holiday for the regular career OPM staff. No, the regular career OPM staff, were all there to assist with the transition. They were all there. To my knowledge, the career staff at least, the leadership was all there. And can you describe what you did for OPM that day, just in general terms, meaning you personally? What I did that day in general terms, we walked over to the OPM building. We watched the inauguration. There was We also signed our paperwork to become, federal employees in our positions. So we signed our appointment papers. We filled out all of our initial employee forms. And there were quite a few of them, as I recall. And one of the HR people, I know her name. I just don't remember it now, right now. She was there and gave us all of our papers. And then I remember we all had name tags. So we went to the conference room. We all had name tags. We had a briefing, or we met with several members of the career staff. We got set up. And so then I think we were waiting for, so then Chuck was introduced as the agency head. And then and then I think that we were, I remember that might have happened around 3 or 4 p.m. when his paperwork came. And then I remember Allison Kidd Miller, our deputy GC, was there. Some members of the executive secretariat were there. And then we kind of did a bunch of work stuff after that. And I think so. I think that's about it. That's about it. What time did you finish working that night? Don't remember. Okay, the new OPM acting director, Charles Ezell, started on January 20th. Is that who you refer to as Chuck? Yes, his name is, Charles Ezell, but he goes by Chuck. Are you having difficulty with your phone? No. Mr. Peters? Okay, because if you need to go off the record, we can. No. Okay, Amanda Scales started as the new OPM chief of staff as well. Objection, vague. Yes, she did. And had you met Chuck Ezell prior to January 20th? No. Had you met Amanda Scales prior to January 20th? Yes. In what context had you met Amanda Scales? We sat, and were introduced on Friday, the Friday before Inauguration Day. And we had a meeting. And we met with her and Brian Bjelde, Bjelde. And I think we talked briefly about what we might do, what might happen on the Monday, January 20th, when we were kind of starting. Who else was at this meeting on Friday before? It was just Brian and Amanda. And so when you said we, were you referring to yourself or any other people who were at the meeting? No, I was just referring to myself. So when you and Amanda Scales and Brian met on the Friday before you started at OPM, you were not yet a federal employee, correct? No, I was not yet a federal employee. And to your knowledge, Amanda Scales was not yet a federal employee at that meeting as well, correct? You answering for what I knew at the time, I didn't know one way or the other whether she was a federal employee or not. I don't think it would have changed how I interacted with her had I known that, but I don't recall having a specific recollection of whether she was a federal employee or not. In January 2025, prior to coming on board as OPM, you were employed by a law firm called Brewer Attorneys and Counselors. Is that right? I was employed by Brewer Attorneys from approximately September 20th or 22nd it might have been early. It might have been the 15th of 2022. So before the end of September of 2022. And then I was employed by Brewer from that time until I think I was employed through Inauguration Day of January 20th, 2025. When did your employment with Brewer end exactly? Which day? My last day of employment with Brewer was January 20th of 2025. Are you saying you overlapped by one day or that it ended? That was the date that I provided as the end date for my employment there. And during that time that you were employed by Brewer, you had some role at the Heritage Foundation's Project 2025. No. Are you aware that you were listed on the Project 2025 website among personnel for that project? I do not recall being, no. To my knowledge, I was not listed. I was listed on a website that was set up by an NGO called Project 2025, like data or something. That was a list that was compiled by an NGO, like based on news reports about who was affiliated with. I think it was Project 2025 Info, and it was compiled by like Democracy Foundation or something like Democracy Defenders or some title like that. But it was not compiled by people it wasn't compiled by like Heritage. It was just a page that they created during the election. I think it was like August or September of 2024, and it listed. So, Mr. Peters, I'm going to interrupt you there, and I don't usually do this, but we're on a clock, and I'm going to ask specific questions, and I'm going to ask that you give me specific answers to the questions that I ask, and not go on these tangents to run out the clock. Is that okay? I was not running out the clock. I was trying to think through the best answer to the question. Understood and appreciated. So the question was, were you aware that you were listed on the Project 2025 website from Heritage Foundation as among the personnel for the project? And I believe your answer was no, you were not aware of that. Is that correct? Objection, asked and answered. Yeah, I mean, not only was I not aware, I don't believe that I was ever on. I was never on the Heritage website as a member or contributor or anything for Project 2025. Were you involved in any way in the Heritage Foundation's Project 2025, Mr. Peters? No. This is not your first time as a federal employee, correct? Yes. So you were the Solicitor General of the FLRA from approximately September 2019 to September 2022. No, I wish I had that title, Solicitor General, but the title was just Solicitor. Oh, I'm sorry. Thank you for that clarification. So is it fair to say as a Solicitor of the FLRA, you needed to be familiar with laws pertaining to federal employment, including the CSRA and the FSLMRS? Objection, leading objection, vague, objection, compound. Well, I would like to. That's great. That's a great setup for cross question, by the way. Well done. But it's compound. And I would have to look at my position description to know exactly what it said. So I don't want to answer inaccurately, but I believe I was during that time. I mean, I did build up a familiarity with the statute and with the CSRA. And is it also fair to say that you have some familiarity with appeal rights for federal employees under those statutes? Objection, leading, objection, vague. I think some familiarity is accurate. You accepted the offer to become senior advisor at OPM, presumably at some point prior to your first day. Objection, lack of foundation, objection to the form of the question. I think that, sorry. Yeah, go ahead. Oh, okay, I got to stop doing that. I accepted the offer to be senior advisor before January 20th. I was fingerprinted in advance of January 20th. And so I probably would have accepted the position about Thursday of the week before. So roughly Thursday, January, I'm going to say 16th, something like that. A rough, yeah, very roughly, it would have been the 16th. And who made you the job offer? So the job offer was sent via email. My recollection is that it was sent by Carmen Garcia, who's our Chief Human Capital Officer at OPM. And were you given a job description, either orally or in writing, for your role as senior advisor to the OPM director? I would have to look at my offer letter to see what was on there. I remember that it being very, very, very general about the job and the job description. Other than the Friday conversation that you have described with Amanda Scales and Bill, did you have any other conversations with anyone about your upcoming role at OPM? Objection, vague. Did I have any conversations with anybody about my upcoming role at OPM? That's a really, really good question. I don't recall any specific conversations about my role. I was, sent the offer letter on Thursday. I remember that I was happy to be at OPM. I think it was very aligned with my prior experience, but I don't recall any specific conversations about what my role would be. Did you help prepare any documents prior to January 20th of 2025 related to your role at OPM? Objection, vague. Related to my role at OPM? No. Related to OPM in general, did you work on any documents in advance of January 20th, 2025? Sorry, January 20th of 2025? Same objections. Yeah, we prepared. I worked on the drafts of two different memos. I think they were the ones that were issued on day one. Who else worked with you on drafts of the memos that were issued on day one, meaning January 20th? Objection, to the extent that this calls for any kind of intra-agency discussion around a draft memorandum, I'd instruct the witness not to answer based on the deliberative process privilege. Mr. Peters was not an employee at the time. That's not a proper basis for an instruction. You can answer the question. I remember I worked on those two by myself. You spontaneously started drafting memos for your upcoming role at OPM by yourself, Mr. Peters. Is that your testimony here today? Yes, I began drafting the memos entirely on my own, and I didn't discuss them until I got on the job. I didn't discuss them with anyone. You just testified a moment ago about a meeting that you had on the Friday before you started working at OPM with Amanda, Scales, and Bill. Is your testimony that you did not discuss those memos at the meeting, Mr. Peters? So the two people were Amanda Scales and Brian Bridgeld, and we didn't discuss those memos. I think we might have discussed different things that would happen during the day, but we didn't discuss those memos in terms of the content or anything like that. I mean, as far as so one of the two was on temporary authorities for Schedule C employees, and the other was the one I assume that you're going to ask about at some point, which was the one administrative leave and probationary periods. And I didn't even know that they had looked at those documents. So your testimony is you didn't talk to anyone about either one of those memos before you started working on January 20th. Objection, vague. I wrote those two memos by myself. Yeah, I don't recall any conversations with people about them. Mr. Peters, the memos were entirely your idea without talking to anyone else? Is that your testimony? Objection, leading, objection, asked and answered. The memos that were drafted, the day one memos, were written entirely by me without any input from anyone else. Let's ask a slightly different question. The idea for the memos, Mr. Peters. Did you discuss the idea for the memos with anyone else before January 20th? Objection, lack of foundation. We might have had discussions about ideas around administrative leave. There was a fellow named Keenan Kmeeks who was involved who I had discussions about the idea, like rules around the administrative leave with. So that memo, I think I might have discussed it with Keenan. What about the part pertaining to probationary employees in that memo, which was issued on January 20th? Did you discuss probationary employees with anyone else before January 20th, Mr. Peters? So to clarify the last answer with Keenan, I think I just talked about the idea of administrative leave. The probationary periods, that piece of the memo was entirely something that I thought of on my own, and I did not discuss that with a soul before January 20th. We'll come back to that. And may I just add to that the idea, what was the thought process behind that was, as stated in the memo, was that agencies would make lists, would simply gather information on who qualified for the category of people who did not have MSPB, for whom there wouldn't be necessarily be a drawn out MSPB process for terminating them. So these would be people on an initial probationary period. These wouldn't be employees who had served a probationary period in another role and then were promoted. This would be people who are simply employees on an initial probationary period in the federal service. And the memo just said, identify who you wish to keep and who you wish to retain. It was, it was not fire every probationary employee, and it was not a direction to agencies to fire any probationary employee. And it wasn't taken, I don't think anybody at the time interpreted it as fire every single probationary employee. Well, let's go back to your idea, which you testified here today was yours alone, to tell agencies to collect the names of every probationary employee and submit them to OPM. That was your idea, is that right? Well, I don't know that it was. So I don't think that I'm not 100% clear on what I've never reviewed what the agency submitted, but I don't think that the agencies even submitted names. I think that was just an internal process that they were going to run through, which is just you yourself identify who these people are. So with that clarification, I don't know if that gets us anywhere on this. The reason that you had the idea that agencies should start identifying all of their probationary employees and report that to OPM was because these employees, in your view, were easy to terminate, correct? Objection, compound, objection, leading, objection, lack of foundation. No, that's not. Why? That's not why. I was mentioning that in terms of defining who was the people that were expected to be on, that we were looking for them to identify. The reason was not because they didn't have appeal. What was not because they didn't have initial appeal rights, though, or because they didn't have appeal rights. The reason was because we cited the MSPB report from 2005, which said that probationary periods are not being effectively used in the federal service to actually like say, do you add like, is your performance such that you're going to be a long-term asset to the federal government? Like get actually using the probationary period to assess employee performance. And the data shows that the agencies were not doing that. The agencies were kind of treating the probationary period as with the expectation that, people are just going to stay and that there isn't going to be any serious consideration of their performance or any serious consideration of the agency's needs going forward. So no, the reason was not simply to pick people who might be vulnerable to like some sort of process. The reason was for agencies to conduct a focused review of who was serving these periods, which is the reason why the probationary periods were created, or they're called trial periods for employees in the accepted service. The reasons they're supposed to be a trial, and the regulations say specifically that the employee bears, the agencies are supposed to use these periods to assess employee performance and see whether they have demonstrated their fitness for continued employment or a continued permanent appointment in the federal service, which has which has important consequences in terms of, getting a degree of a very kind of high degree of process around termination. But, the agencies have always been encouraged to use the periods very stringently, but it just wasn't happening to my knowledge at the time. So that was the reason you thought it was a good idea to write this memo telling agencies to collect lists of all of their probationary employees, because you believe the agencies were not using the performance assessments correctly. Is that right? Objection, lack of foundation, objection, leading. Yeah, I mean, it's certainly a leading question. This is cross, by the way. No, I understand. It's just, and you're doing what you're supposed to be doing, which is leading, and especially given the short time frame, it absolutely makes sense for you to lead and lead very aggressively. But sorry, can you repeat the question? Goodness gracious. This had been my witness, I would have been, whoo. Sure, I'll ask a different question, actually, Mr. Peters. So when you had the idea, let me see. Let me go back to what I was going to say. I'll ask Mr. Peters. I'm going to ask a different question. Yeah. So, Mr. Peters, when you had the idea for this memo telling federal agencies to collect the names of all of their probationary workers, when you had that idea, you believed that those employees had fewer appeal rights to the MSPB than other civil service employees, right? Same objections. I think that the idea was that there would be new leadership at the agencies who could give a fresh look to some of these issues, because we wanted to make sure that agencies had effective, this one, want to make sure that agencies have effective performance, systems. And so but as I said, the fact is that you can't kind of separate the process from the substance in this case. The reason why the substance is different is because the process ramps up radically after the probationary or trial period. And so they're kind of interconnected. So we're not just kind of picking people in the schoolyard to go, and say, hey, get that guy. The reason is because the process that is provided for in the federal statute, it's higher because you have a gating mechanism, because you have a trial period. So it's almost like, think about it this way. When you go to court and you get a judgment, right? Okay, I'm going to cut you off with the narrative because it's non-responsive. I'm going to move to strike your answer as non-responsive, Mr. Peters. The entire answer? I'm going to ask you to answer the questions that I ask the question, Mr. Peters, is when you wrote this memo, which you have testified was your idea alone. Yeah? And you own that was that memo on January 20th, telling everyone to collect the names of their probationary employees. That was your idea. Objection, asked and answered without talking to anybody else. Is that your testimony? When you say own that's kind of colloquial. Own it in what context? Is that your testimony, Mr. Peters? My testimony is that the memo, and particularly especially the part about probationary periods, was entirely my idea, and I never spoke about it with anybody later, like before or later, until, well, into my time at OPM. And when you wrote that you believe that the process, as you just described it for probationary employees, is to object to any termination, was less substantial than the appeal rights for civil service employees, right? Objection, vague. That's a yes or no question. Well, think about it so it's called a trial period, right? Think about it like you have a trial and then you have a judgment, right? And it's actually very, very difficult to undo a judgment because what's gone into a judgment has been a lot of vetting, a lot of work, a lot of scrutiny. So it can be easy for a judge, for example, to change his mind before the judgment. I do not do this. I'm going to interpret you and ask you to answer. I'm sorry. I'm going to interrupt you, and I need interpretation, everyone. I'm going to interrupt you and ask you to answer the questions. If you continue to do this, I will hold this deposition open. We will get more time from Judge ASAP, and you will be back in here longer. So please answer my questions directly without these extended narratives. Can you agree to do that, Mr. Peters? Yes or no? Yes. Please don't badger the witness. Thank you. At the memo on day one, January 20th, that was issued to all federal agencies. Do you recall that? Yes, the document said that it was issued to, it went to all heads of all departments and agencies, and I believe it also had a CC line on it as well. And you gave all federal agencies 4 days, including the federal holiday, until January 24th to collect the names of every probationary employee. Do you recall that? Objection, lack of foundation. The memo went out, did not go out from me. It wasn't me, Noah Peters, giving people a deadline. It was the agency. It was from the agency had, Chuck reviewed and signed it, the memo. So I didn't send anything out to the heads of departments of agencies. Are you suggesting that Chuck Ezell changed the deadline you had drafted and made it January 24th? Is that your suggestion, Mr. Peters? Objection to the extent that it calls for testimony about internal agency deliberations once he was a senior advisor. I instruct the witness not to answer on the basis of deliberative process privilege. You have to put the facts at issue with respect to what was told to agencies. Mr. Peters has submitted a declaration. You've waived any privilege that pertains to this. We can address that during a break. I'm not going to waste time on the record on that, but you've put the facts at issue and the privilege is not well taken. We'll call the judge during a break to get clarification on that. And I suspect I know where he will land. But for now, we'll move on. I'm going to mark this as Exhibit 1. And then Exhibit 1 was marked for identifications. And Mr. Fucci says, yeah, I'll say for the record, communications with agencies, but communications with OPM would be subject to deliberative process privilege. And we haven't waived that privilege. We'll discuss it during the break. What was the waiver? We'll discuss it during the break. Okay, we're marking that as Exhibit 1. You can hand that too, so that's yours. That's the copy. For counsel, you can take the copy with the exhibit. Number on it is for you. Okay, back on the record. And I will stop there, everyone. I did want to stop before we got into the exhibits. So let me go ahead and do our Q&A here. We have gone through 40 pages of the deposition. Let me bump my camera up here and take our Q&A at this point. Okay. Okay, comments should be on, hopefully. Hello? Is anybody out there? Are we getting comments? Hopefully. Tea break. Thank you. Oh my goodness. Hello, everybody. Hello. Hi, John. Good afternoon. Oh my goodness, everybody. I stumbled across this deposition and I thought, oh my goodness gracious. Oh my goodness. What are these Looney Tunes doing? He's trying to keep from implicating everyone. I agree. Good afternoon. Hello, Deb. Hello. This witness. Oh, I know, right? Before 10 a.m. Yeah, it's early. It's early. That was a lot. It was. Hello, Alyssa. Welcome. So again, this is one of our lawsuits against the administration that's slowly meandering and making its way through the process. But this is our first deposition where we've actually had somebody who was in charge of making these decisions and issuing these memos from day one being asked about it. Right. Well, you start throwing stuff, right? But you have to just mentally just throw stuff. Claiming to not be, the witness is claiming to not be in charge of what he's in charge of. Exactly right. Yes, exactly. That witness. Oh my gosh. I know. Oh, so, I mean, again, the unions here are bringing suit because they fired a whole bunch of people. And the reason they gave for firing, because, you have to have some reason in most situations, is bad performance. And so she's slowly walking them down the road of, no, you came in on day one deciding that you were just going to cut a bunch of people. It wasn't about their performance. So she's just setting it up. Didn't the Supreme Court rule on this? We've had a lot of different things going on with the probationary employees, and we also have had rulings regarding federal boards at this point. So this one, I do not have a decision on that I can give you. We've had a lot of things saying you can hire them back, you cannot hire them back, but this one's actually the rationale for the termination, if that makes sense. I don't have the closet docket in front of me, so I can't. I can't give you the case. We did have some really big questions about, the extent of the authority that was allowed to go through this entire process as well. So, yes, so there a lot of movement on this case. Yeah, there's, it's, and in a lot of the other cases too, it's going up and answering one specific question and then going back down again, and then going into court through that process. And that's one thing too, whenever we get any of our decisions from the Supreme Court on any of these cases, their decisions are going to be limited to overturning the restraining order or vacating the restraining order or upholding the preliminary injunction or that kind of level, because we're only in those first few steps. Noah went to how long has Mr. Peters practiced law? That I don't know. So, right, this deposition was filed yesterday. The deposition itself was done on March 26th. And nothing to do with performance. Exactly. Right. That's exactly it. That's what the question is for this deposition and the intent behind it. Because too, if even, if they come back and say, well, you can be discharged for any reason, the fact that the reason was for poor performance, that'll go with you. That'll follow you into your next job. So that's something that has to get sorted. Yes, he was. He was. Came up with these ideas. Yeah, he just thought about them himself. He wasn't involved. He didn't talk to anybody about his ideas, right? Yeah, that's the problem. See, if they just sent out and said, okay, bye, first of all, they have to have a reason. I mean, there's federal statutes involved in that. There has to be some kind of a rationale. So, they're like, well, whatever. But if they come in and say it's because of poor performance, that's a huge red mark on your record if you're trying to go forward in your career. And so that's one of the biggest issues here. So if you're going to terminate them, use a legitimate reason that doesn't negatively affect their future work. Oh my gosh, the humiliation technique because of the lack of empathy is outrageous. It's absolutely outrageous. And just continues to show how if you can't have empathy for other human beings, you can turn into a monster. And all of these little minions can be monsters too. Just sheer humiliation. Like, you've got 2 hours to leave a house. Like, I think wasn't there, I can't even remember, a military woman in the Navy, and they're like, you got 4 hours to leave this house that she had been in. It's like, dude, that's not necessary to achieve your objective. The only thing that's necessary for is for, you to be playing a power game. Yeah, it's really awful. Unions don't have standing. Is that what it came out as to bring the lawsuit? Yeah, and that could be. And I'll have to look up that full decision because we've got, I think, 3 major probationary workers lawsuits. So that's the only reason why I'm hesitating, is because I'm not sure exactly which case. The other thing, too, is after looking and saying that wanted to remodel exactly. The other thing, too, is if they're saying that the unions don't have standing because the unions aren't the ones being hurt, then you have to go and you need to get specific people. So rather than the organization with all of the funding and the power behind it, then you have to go in and you got to find who the employees were. And then you bring them... Right. Then you bring them in front of the court. Yep. Exactly. There you go. Yep. MZK. Exactly right. But again, and the unions can come in and back them up. And like this deposition can be used in any case involving this person, Mr. Peters. This deposition can be brought in to show what he was told to do, what he did, what he thinks he did. This lasts forever as basically, sworn testimony, because that's what it is. Yep. That's, and that gets tricky. We've always had a standing question when it comes to an organization made up of people versus the people individually themselves. That's, what the deal that we, standing has to deal with each time. So, yeah, they have to go through that craziness. Took full responsibility, right? So many cases that lack standing go to the top anyways. If it gets through the hurdle of standing for the lower courts, then there must be some kind of question if they're not definitive in their standing answer. You know what I mean? Like there's the case won't keep going if it's a bad case. There has to, the doors have to be open through the courts. So there must have been some reason why they keep the doors open. That has to get closed by another court. Right. So class action, what you have in a class action lawsuit is you've got the designation of a class, so a group of people who've been harmed and who will be repeatedly harmed in the situation. Yeah, that was weird, wasn't it? Juris Mac, that was weird. The Christian bakery situation. And that's some kind of a weird piece of the standing law doctrine because, it has this future harm, and they used it based off of how Colorado had implemented the law previously in a prior case, and that there had been harm done. So, like, they were called out in front of the county board, I guess, and they're like, well, look, there you go. They got called out for it. And so they were saying this could be another case where harm could be done. So that's why they were able to predict the future in the Colorado case. Yeah, I agree. I agree. Yep. Continue answering. Yeah, and that's the thing about depositions is you can ask your question and you can object to the question, but you keep going. The objection, then you argue later. So that's another thing that I think is one of the strategies here is that this attorney, Mr. Fucci, is just like objection, 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 objection. So he can come back and complain to the judge later and get certain things stricken. So if the judge rules one way or the other, then you wouldn't be able to use certain testimony. But we've seen it. We've heard it. We know what it's been doing. Mr. Sneaky here. Yeah, no judge. But what she was saying, though, and we do this all the time, is she was saying during our break, we'll call the judge. They were trying to, when the attorney is putting forth, I'm instructing the witness not to talk, we're asserting a privilege, then that's when you need to get a judge involved because she's going to want answers to those questions. And if he's saying, well, it's privilege, we're not going to give you answers to those questions. And she's like, well, we need a judge to make that decision right now. So they can just call in. Right, to see what might stick. Yeah, the objections are on the record. Yeah, all of the objections are. And again, our objections are based off of the rules of evidence. So, it's not like, oh, that doesn't sound right, and then you object. You have to have specific rules. Now, when you've been litigating for a really long time, sometimes you'll just do an objection like, 401 objection. But other times it's easier to just say, relevance. I object to relevance here. So it just depends. But each objection's going to have a rule that goes with it. And so then you argue that rule to see if you're allowed to keep the testimony or not. Yeah. That's kind of the key with objections. So leading, you can't lead unless it's a cross, but depositions have different rules and those kinds of things. Oh, yeah. I mean, it's awful. It's absolutely awful. They have just torn through so many lives. So many lives. And it's heartbreaking. It absolutely is. For sure. So, yeah. Anyway, I'm taking a look at my clock here, everybody, and I'm going to have to close our lunch and learn down here. But hopefully this was interesting for you. Got a little peek into what's going on. And again, all of this testimony where we assess the authenticity and the credibility of this guy, this is all now on the record. So it's can be used at any point. And if this guy's right, the one writing the memos, he's going to be called to testify a lot. So thank you all for coming in. Yeah, exactly. The verbiage is key. Thank you, moderators, for coming in, hanging out. I know it was kind of a last minute hopping on, but very interesting. So I will put this live up on to my YouTube, and I will be doing another live to continue to go through this deposition. I'm not sure exactly when. So when that point comes, I'll make sure and let you know, everybody. So have a good rest of your day. I'll see you all again very soon.